these characteristics, it's phenomenal, but also me and Blake did have a couple conversations before I started filming, and me and Blake were already just on like such a similar page. It's pretty unbelievable.
Yeah.
I was so shocked that it was just so seamless with, we had such a similar idea of who Lily was, and it just really helped a lot to be able to go, okay, cool, this is what you think, this is what I think. And Blake is such a wonderful, giving actor to me about how this is just as much my role as it is hers.
Hi, besties. Isabela Ferrer has entered the chat, and she has entered in a very big way because she has filed an opposition to the court to oppose alternative means of service and to demand sanctions against Baldoni, but then doesn't request that the subpoena actually be quashed. And the filing is a strange, odd filing because the tone of the motion, it's like 26 pages, includes extremely hostile and vitriolic language accusing only Baldoni and Baldoni alone, not Wayfair, which is odd because these subpoena is not from Justin Baldoni. It is from the Wayfair parties. But Isabela names Baldoni over and over and over. Strategically, it feels like. And in the filing, it makes all sorts of accusations that parrot and mimic accusations that had been made against Blake when it came to content creators and their subpoenas. And the demand for sanctions, along with using language like quid pro quo, which is like a bribe. And if you recall, I told you a couple weeks ago that Ryan Reynolds did a quid pro quo with Vancouver's law enforcement to try to get someone arrested. And now here on the docket is someone accusing Justin of quid pro quo. There feels like some collaboration here with Lively, and obviously there must be because Isabela actually, she cooperated with Lively's subpoena, and she gave Lively the communications that she requested, but she's been fighting with Wayfair behind the scenes about indemnification. Indemnification meaning Wayfair would pay for anything that Isabela gets tied into in a lawsuit if it comes out of the film, okay? And when an actor is hired or an employee is hired, it's basically like an employee saying, if you get pulled into something that is a byproduct of your work, we will cover the costs of your legal fees and we will take care of everything on your behalf. But apparently, Isabela doesn't want Wayfair to help her, and instead she wants to use her own lawyer. And which is fine, but if you're going to go through your own lawyer, then there's obviously going to be disagreements about indemnification because generally with indemnification, it means the employer covers the legal side of things, basically managing the subpoena for you, handling the document production, getting it to Lively for you. And she didn't want anything to do with that, and she wanted to use a lawyer herself. Now, the lawyer is hyperbolic in his language towards Justin, hyperbolic, and I would say extremely inflammatory about this situation. And I found it odd because he was calling Miss Ferrer being subpoenaed by Justin a campaign, an ongoing campaign of harassment against Ferrer. What seems clear to me is that whatever's happening here is that Blake is coordinating with Isabela. The language is almost a mirror copy of the same sort of stuff that Blake files on the docket or Ryan Reynolds. And it just seems very, I don't even know, I can't explain to you how odd this, when I read the filing, I was like, none of this even makes sense. You're mad that you're getting subpoenaed. You weren't even brought into this by Wayfair. Lively brought you into this by subpoenaing you. But she blames Wayfair for naming her in their complaint. Just to give you a couple ideas of what they say. Miss Ferrer tendered a demand for indemnity to It Ends With Us Movie LLC as mandated by her day weekly player contract for theatrical motion pictures. Okay. From that point, Baldoni has tried to manipulate, threaten, control, and otherwise act inappropriately towards Miss Ferrer. Wayfair Studios is not just solely owned by Mr. Baldoni, by the way. It is a joint partnership, and there are multiple members of this company. It's mostly owned by Steve Sarowitz. So it's odd that if you consider the fact that the CEO of Wayfair is Jamie Heath and Steve Sarowitz and his companies are the primary backer, the financial backer of this company. It's odd that everything is just getting targeted at Baldoni. It also seems odd when you're discussing a subpoena to claim that someone is being controlling and threatening and intimidating and acting inappropriately because it's a subpoena. It says, in fact, his team has gone as far as citing a phony case, which her counsel discovered as an AI hallucination to support a frivolous legal position. But it did not stop there. The filing of the instant motion is yet another attempt to manipulate the press, to create havoc on a young, up and coming, talented actress, and to violate this court's policies on publishing of a non party's personally identifying information. What is clear is that aspects of the subpoena that Baldoni served on Miss Ferrer almost mirror what she got from Lively. But oddly, she doesn't call Lively's subpoena of her harassing. Okay. So she says that because he's asking for documents that she's obtained or she provided to any other subpoena she has received in this litigation and provide that to him, which is the exact same question that was served to her by Lively. Lively served her a subpoena and said, any documents you've provided to anyone else in any other subpoena in this action, which is like, she didn't call it a threatening or intimidating or harassment for Blake to ask that, but she's saying that it's harassing for Baldoni to ask that. And they're claiming that he's only doing this to paint her as not complying, and yet her attorneys don't address the fact that they haven't accepted service. Instead, what they do is they say that it's quid pro quo. So they're saying Baldoni tried to leverage compliance with contractual indemnity obligations owed to Ms. Ferrer in an effort to take control of her response to the Lively subpoena. I'm not sure about that. I think it's when an employer is paying, they pay for your attorneys, and because they're indemnifying you, they are going to manage it for you. But she's viewing that as, you're trying to control me. So they had a disagreement about that. And then they're saying Baldoni then tried to leverage compliance with those same indemnity obligations as a quid pro quo for her to instruct her attorney to accept service of the Baldoni subpoena on her behalf. What I find odd here is that there is no communication whatsoever between Baldoni and Ferrer. It is Mitra, who is one of the attorneys for Wayfair, and Ferrer's attorneys in an email exchange. And there's nothing that appears harassing or even a quid pro quo. It is her saying, okay, we're working on this indemnity issue. We have a judge that's going to determine if these invoices will get paid, if it falls within this clause. And then we have a subpoena for her. Will you accept service? But Mitra was only asking on behalf of someone, Jason Sunshine, who had subpoenaed her. So her colleague Jason had subpoenaed and sent an email to the same attorney who said that he was representing her. And so instead of responding to it, he just ignored it. So he didn't answer the questions about what she was seeking, about the indemnity issues that were brought by apparently the mediator and arbitrator that they're using so that they're all in agreement when they start looking through the invoices. They're saying that's a quid pro quo. What is not a quid pro quo? He's either, as an attorney, he's either one of two things, representing her or he's not. And so it kind of felt like for 26 pages or 30 pages of this, it's really just them being angry that she's being subpoenaed to begin with. And it says Ms. Ferrer rightly refused to tie her indemnity rights to any other legal issue in his dispute with Lively. A subpoena is a court order, and whether she wants to acknowledge it or not and have her attorney acknowledge it or not, it's not a quid pro quo for a subpoena to be issued and then to seek and have to comply. And the judge in this case, he's dealt with this with other parties. So, for instance, Stephanie Jones subpoenaed Koslow and Case from TAG. So did Lively. Two separate parties subpoenaed the same individuals. Koslow and Case had to produce documents to both Lively and to Jones. Even though they're all sharing the same information, not all of the requests for documents are identical. So he approved a motion to compel for Jones that Case and Koslow comply with their subpoena, even though they had already turned over documents to Lively. So I don't know that Lyman's going to view this as a harassment, specifically because not only did Wayfair note that she was a witness, but Blake, in her initial disclosures, listed Isabela as a witness. And because a witness is on a set and they have information about experiences and then they had information about promotion, it's obvious that she has information to share. So it's very different than subpoenaing a content creator who has nothing to do with it. I don't know if Ferrer has been wildly influenced by Blake and is viewing Baldoni as a predator, but it very much feels like that. And it feels like she's taking this very personally, which she's very young. So I don't want to harp on her. And it's scary to get brought into litigation. He notes that she will faithfully comply with obligations under any subpoena, summons, or court order, but she will not be intimidated or extorted by any party to participate in the proceedings. First of all, you can't be extorted to participate in a subpoena. That doesn't even make sense. If you're subpoenaed, you have to respond, and you have a couple options. You either can comply or you don't comply. And if you don't comply, you have to file a motion to quash. Wayfair, behind the scenes, they attached emails, by the way, has been trying to communicate with them since July 3rd to have this subpoena served. And when they served it or tried to serve it, Jason Sunshine, one of the lawyers, emailed Isabela's. And then not long after, apparently, Mitra emailed on a different issue related to indemnity. And so what he's trying to say is that in order for them to pay for and indemnify her, she has to accept service of this subpoena, which is really not what they're saying. It's that it's two separate legal issues, that they have a right under the discovery rules of civil procedure to subpoena her. She's listed as a witness. And they're tying that as a quid pro quo, which isn't really a quid pro quo, but they're trying to claim that the only reason that Baldoni brought this to the court to begin with is to harass her, and it led to negative publicity for her. So it ends with us did not and would not send Ms. Ferrer an executed copy of the engagement contract needed to engage the JAMS neutral until Ms. Ferrer responded to Ms. Mitra's demands. When Ms. Ferrer's counsel unilaterally submitted a partially signed copy of the JAMS engagement contract to JAMS, almost immediately sent back an email stating, "Will you accept service of the process on behalf of your client?" referring to Baldoni's subpoena. In this way, it ends with us indicated that if she wanted to move the indemnity dispute resolution process forward, her counsel would need to accept service. I don't know that that's saying that. It's, again, two separate legal issues, and they're claiming that it's a quid pro quo. And then because they didn't respond for over a month to them, they went to the court. It says he filed his motion on August 12th. Only after filing the motion did it ends with us finally return a countersigned copy of the JAMS engagement contract. The coordinated timing of these two events highlights the quid pro quo nature. Well, no, I think it's more like they have a deadline for documents. And I don't know. All of this just seems like it's just absolute nonsense. And again, doesn't really tell me that she is going to respond. And then they're mad that she got negative publicity of it because of an article by Us Weekly, which his motion wrongly asserts that Baldoni explained that Ferrer's lawyers failed to respond to the subpoena, making it seem as though Miss Ferrer disobeyed a validly served subpoena, even though she has not, and that narrative is utterly false. They never said that she disobeyed. They said that the attorney didn't respond. He didn't, and this is an article, by the way, not Baldoni. They go on to claim that because he posted addresses that were not even her addresses, now the people at these addresses are being harassed, but she doesn't live there. And so that was also done only to intimidate and harass her because the court had just issued an order that all PII could be redacted moving forward without a request from the court. The issue here, though, is that that order from the court came in the exact same day that they filed the motion to serve her alternatively. And we have no idea what time they submitted that versus when the court order came. So if they submitted that to the court before that order came, they weren't violating really anything. And that part was like, okay, this makes zero sense to me. Then they go on to claim that he's not actually tried to find her and that the purpose of the motion and subpoena is to harass her as a part of a broader coordinated campaign against her. That sounds like she's trying to claim that he is smearing her too. But to be fair, I don't think, I mean, some people are upset with Ferrer, right? And they feel like she is a Blake Lively puppet or a muse or whatever. And trying to subpoena someone in a lawsuit of an actress that was on your set that's listed as a witness isn't really harassing anyone. And it feels like she's really owning this narrative that was told to her by Blake that he's a predator. Both the motion and the related Baldoni subpoena have an underlying purpose that go well beyond pursuing legitimate discovery from a non-party. A subpoena that requires a non-party to produce documents produced in connection with any subpoena in the action is not aimed at uncovering new evidence or information. Blake asked for the same thing. Those documents are, by their very nature, materials the parties have readily available in the litigation. Instead, the motion and Baldoni subpoena are transparent efforts to exert pressure on her, both in the litigation and connection with other pending disputes. Rushing to file the motion before conducting the necessary diligence to support a proper request for service by alternative means allowed Baldoni to publicly disseminate addresses that could have been her home. This sort of conduct is not new, and Baldoni has been improperly attempting to exert control over her ever since she received the Lively subpoena. Exert control seems very, very, I don't know. Again, it feels like a narrative that's been pushed by Lively's team. They're claiming that they're doing this to promote a public scandal, that he disseminated private identifying information. He wants to control her response to litigation. Baldoni's demand that she cede control of her subpoena was truly an egregiously improper demand, and though does not rise to the same level of severity as attempts to control the substance of a non-party's discovery response, Baldoni has tried to those leverage the same contractual obligations as a quid pro quo for her instructing one of her attorneys to accept service of the Baldoni subpoena on her behalf. They have said quid pro quo so many times in this document. So what they want is he has not met the threshold for seeking to serve her by means other than personal service because he cannot show the requisite diligence to support such a request. Rather, he filed the motion for improper purposes and with the aim of harassing her. And she asks the court to deny the motion and take appropriate action to protect the non-party PII that Baldoni recklessly disclosed publicly through his filing. She wants sanctions for his bad faith tactics. Thus far, the judge has been unwilling to do any sanctions for anything in this case, so I just really don't see that happening. And I don't know how it's, again, harassment in her to subpoena her. And the harassment is because it covers the same information that Lively's subpoena covered. It's just so odd. The overlapping categories are Miss Ferrer's communications with Lively, Baldoni, and other parties, harassment or discrimination that took place during production, complaints or grievances about various people connected to the film, communications about intimate scenes from the film, and he made no effort to tailor the subpoena towards the production of new or different materials, which demonstrates the aim is to harass. I don't think so. And then they attached all of these attachments and the letters and the emails, they just to me don't look like harassment of any kind. In fact, they just look like lawyers trying to work through a dispute. So she doesn't like that she got negative press, and that's unfortunate. I don't know. What we know is that Isabela, according to this, only spent 4 days on the set, doesn't have as much contact with Baldoni as she does with Blake. We know that Blake wined and dined Isabela, flew her out to stay with her, brought her to Deadpool premieres, invited her to openings of her hair care line, has styled her and like given her all kinds of access to friends, has lied to her and said that Taylor Swift was involved in casting her, which Taylor has flatly denied, has really spent way more time with Isabela through the promotion than Baldoni ever did. And Isabela doesn't deny that she sent a nice text to him, but that wasn't the narrative she had about him, which again, she sent the text. She doesn't like the way it was portrayed in the document. And now she's saying that he's harassing her by trying to subpoena her. And she could have just filed a motion to quash, but then she'd have to select service. But then the issue here is that then what do you do with the subpoena? So are you going to accept the subpoena or not accept the subpoena? You spent all these pages telling the court you weren't going to accept something on a quid pro quo, but then you file into the court and then you paint this narrative that he's harassing you, but then the subpoena issue is still at issue. And I've watched a couple attorneys talk about this, and I talked to an attorney yesterday about this, and all of them just said, none of that matters. The issue is the subpoena. And under the law, she either accepts service or it appears she's evading service. And even though they're claiming they're not evading service, she is because she's not responding. And they did try to serve her at addresses that weren't hers, and she doesn't have two residences, and she's not wealthy, and she only got paid a small amount. I don't know. There's definitely been an influence, in my opinion, by Blake. Blake spent a lot more time on her. She love bombed her, and it would appear that they're cooperating with Lively's side. So now the narrative in the press will be that, another actress is accusing him of inappropriate conduct, but she can't speak to anything that's happened on the set. Only lawyers trying to figure out indemnity issues under a contract and a subpoena, which would not be inappropriate. So Ryan and Blake, I guess they strike again. Tell me what your thoughts are in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed, and click the bell so you never miss a video. Thanks so much for watching. Bye, besties.